I'm still waiting for some indication from you that the right space ordinance is indeed bigger ammo.
I guess I'll just reinforce what Mr. LaVoy said. Absent litigation that says that they're not going to win, yet saying that they've moved on or they've gone somewhere else doesn't necessarily mean that at some point this wouldn't be up for test. And if it comes up for test, it's going to get all of the litigation and all of the expense that another ordinance has. I mean, I'm not suggesting we can't do one or the other, because that's not what I want to do here. I just want to point out that saying it's rights-based and therefore we're not going to have litigation is
I didn't say that.
Well, you certainly have implied it.
That's it. I'm just going to sort of take a moment of our time here and pick out 3 items in the right space ordinance that I think are problematic, and I'll leave it to everyone else to form your own opinion on it. Section number 5, statement of law. No corporation doing business within the town of Wells shall be recognized as a person under the United States or Maine Constitution or the laws of the United States or Maine, nor shall the corporation be afforded the protections of the Contracts Clause or Commerce Clause of the United States Constitution or similar provisions within the Maine Constitution. Now, that, whether or not corporation is an individual under the eyes of the law, was decided by the U.S. Supreme Court back in the early 1800s. So there's one cornerstone of this ordinance that we know is readily defeatable in U.S. court. Then we go to section 5.1, rights. All residents of the town of Wells possess fundamental and unalienable rights to access, use, consume, and preserve water drawn from sustainable natural water cycles and provide water necessary to sustain life within the town. Natural communities and ecosystems possess unalienable and fundamental rights to exist, flourish, and naturally evolve within the town of Wells. Recent U.S. Supreme Court decision stated that only individuals have rights in this country, that ecosystems, endangered species, laboratory rats, primates and zoos do not have rights. Humans' treatment of those things can and should be regulated, but those things do not have rights under the U.S. Supreme Court decision. And then section 7.4, town action against preemption. I won't read the whole thing, but I'll just read the pithy part here at the end, where it says that any attempts to use county, state, or federal levels of government, judicial, legislative, or executive, to preempt, alter, amend, or overturn this warrant article or parts of this warrant article, or intimidate the people of the town of Wells or their elected officials shall require the Board of Selectmen to hold public meetings to explore the adoption of other measures that expand local control and the ability of residents to protect their fundamental and unalienable rights to self-government. Such consideration may include actions to separate the municipality from other levels of government used to preempt, alter, or overturn provisions of this warrant article, or levels of government used to intimidate the people of Wells. Now that basically says that we reserve the right to secede from Maine or the United States if we don't like the court decisions, and I would submit to you that was decided by the Civil War, that wasn't about to happen either. So what we have here are 3 of the 4 fundamental principles, 4 corners, 3 of the 4 corners of the foundation here are resting on sand, and unstable sand at that. I don't see any way that this ordinance would be sustainable to any challenge.